All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in CV21 0580, McGill versus Ball. Counsel, we have read the briefs in this matter. We've conferenced it this morning in conference. Both sides have 20 minutes to present your argument. Please stand to the podium when you do and announce the party for whom you represent when you do so. Mr. Abney, you may begin.
Used to a longer speech. Sorry, Your Honor.
My name is not up to it today, so go
yes,
ahead.
I understand. May it please the court, my name is David Abney. I represent the appellant in the case. Might as well start with one of the harder propositions. It's our position that Attorney McGill was an employee of Judson Ball and pace setter, and because of that, the article that deals with the enforcement of arbitration agreements, and specifically 12-15-12, ARS section 12-15-12, does not apply.
Counsel, what evidence in the record is there that McGill was Ball's employee?
There's no specific finding that he was an employee. However, the facts indicate he was an employee. He was hired to do a specific job. Now, we commonly think of attorneys as independent contractors, but that really doesn't matter for this purpose. The statute has no definition of what an employee is. Therefore, you have to go to the common meanings of the word. And the common meaning of employee is somebody that you hire to do a job.
Wouldn't the common meaning be more consistent with independent contractor employee, the distinction between an independent contractor? Presumably, an employee acts entirely at the direction of an employer. Isn't that very different than an attorney deciding how to pursue a legal matter?
Well, in the general sense, when you just talk about are you an employee or are you an employer or not, you're talking about you hire somebody to do work for you. That's all there is to that, really, when you get right down to it. In fact, there's an example that's out of the unabridged dictionary that talks about hiring an employee, hiring an attorney, employing attorney to handle a legal matter. And that's really what you're doing when you're hiring an attorney. I mean, you've all worked for institutions like the Attorney General's office. You were an employee on a salary there. But if the Attorney General had brought you in to handle a specific job, you weren't on salary there, you'd still be an employee of the Attorney General. There's nothing here that takes McGill outside of what would commonly be regarded as an employee. And because of that, under 12, 15, 17.
It's the question that Judge Catani asked. Generally speaking, when you hire an attorney, you're hiring that attorney for his expertise, but you don't control what he files in court or she files in court. You don't control that at all. That's entirely up to the discretion of the lawyer.
Right.
Well, that's not the traditional sense of what an employer-employee relationship is it, Mr. Abney?
It's a specific kind of employee, sure, but it's still an employee.
And so even if I hire an electrician,
right,
is that electrician to rewire my house? Is that electrician my employee or my independent contractor to do a job?
He's your employee and he is an independent contractor, but you've hired him to do something. He's your employee for the period of time that you've employed that person. You may not be able to tell him much to do about
zero. I couldn't tell him anything to do other than when I turned the light switch on, I wanted it to come on.
And hopefully it works. But of course, an employee, there's distinctions here in other areas of law. Workers' compensation, there's a huge distinction between employees and independent contractors, often hard to make. In tax purposes, there's a distinction between independent contractors and employees. But we're not talking about that. We're talking about, in general, was he an employee? And the answer would be yes. Under the standard common meaning of the term, he would be an employee. And
common meaning, I hire a restaurant to cater reception at my house. They're my employees.
If you hire a specific person, whoever's in charge of it, that's your employee for the period of time that they're doing work for you. You can fire them at any time you want, which is one of the hallmarks of being an employee. And certainly Judson Ball could have fired Mr. McGill anytime he wanted to. It was an employee. Why not? Anyway, I think I've outlined that pretty well in the briefing, and I've done what I could here today. The other thing is, one of the important things is, well, what do you do about this binding arbitration business? It's not in the contract, nowhere. But McGill wants to add it into the contract. You can't do that. If it's either in the contract or not in the contract.
Why did Ball wait to raise the question of whether it was binding or non-binding until McGill sought enforcement of the arbitration award in the Superior Court?
He didn't really bring it up right then. We didn't realize, quite frankly, I had made an error. I had put it was a binding arbitration in a confidential memorandum. It just blew right by me. It was an accident. My co-counsel missed it. Judson Ball missed it. We all missed it. We went to the arbitration very relaxed and easygoing because Judson Ball, he was regarding this as going to be, well, okay, there's going to be an arbitration. I agree to that, but I don't have to be bound by it. And if I don't like what happens here, I'm not bound. So none of us were worried about the arbitration at all. And it didn't come up actually until we disclosed as part of the discovery in the case in Superior Court our confidential memorandum. And we still didn't realize what was in it. We never really looked at it. We just gave it to him, and all of a sudden he comes back and says, gangbusters, you guys are horrible people. It says right here this is a binding arbitration, and we said that was a mistake. And I'm sorry about that.
Even without that, though, what about just the statute 123006, an agreement to arbitrate is going to be valid, enforceable, and irrevocable. So what's the point of an enforceable and irrevocable agreement to arbitrate if it's just, we'll do it, but then it doesn't really matter. We're not bound by it.
Well, I don't know what the purpose is. I mean, you can have a binding arbitration, you have a non-binding arbitration.
Does the statute ever make a draw of that distinction? Does the statute ever draw that distinction between a binding arbitration and a non-binding arbitration?
You're talking about 12, 15, 12, and all this? No, it doesn't say anything about it one way or the other.
So under the statute, arbitration is binding if it's agreed upon by the parties. Wouldn't it take an affirmative non-binding assertion in a contract to take it out of the statutory requirement?
No, it doesn't say anything about binding, non-binding. You can write it however you want it, and if you don't say that it's binding...
As Judge Catani read to you, it's enforceable and irrevocable if it's in a contract. It's binding. It's binding. Unless you take it out and you specifically put in your contract, it's a non-binding.
Wasn't the language more like the agreement is binding? I mean, the agreement is enforceable? Something like that?
It is, but it's an agreement to arbitrate. And what's the point of saying it's enforceable? Contracts are enforceable. Why have this provision unless it's saying an agreement to arbitrate is valid, enforceable, and irrevocable?
Right. That's it. I'm sorry I missed that the first go around. Yeah, the agreement, we fulfilled the agreement. It was binding. We did it. And that agreement was binding. However, the arbitration itself was not binding. We were stuck with the language in the contract that says Attorney McGill can choose to go to an AAA arbitration, which would be binding, or just another arbitration, and it's up in the air whether that's binding or not. You need to put something in the contract that says it's binding or non-binding. And they didn't do it.
What do you make of the legal authority from Black's Law Dictionary that refers to binding arbitration as being redundant?
Well, I admire Brian Gardner immensely, but that one he got wrong. I mean, you can have a binding arbitration, you can have a non-binding arbitration. It's up to you as the drafter of your contract to put in which one you want. And in fact, one of the cases he relies on, this phone jockey case, it has it right in there. This is a binding arbitration. And it's not in this particular case. Judson Ball submitted evidence to the trial court, Superior Court, saying, I never thought this was going to be a binding arbitration. And for what it was worth, I and my co-counsel, Tom Smith, submitted declarations to the same effect. But what most matters, of course, what really matters is what Judson Ball put in his declaration.
Mr. I just want a record clarification. It's my understanding that at the arbitration, your client indicated what he believed was he owed. And that is actually what the arbitrator imposed. Isn't that correct?
No.
Is there a distinction between the two? How much money did your client admit in the arbitration was due and owing under the contract?
None. He paid over $140,000.
And nothing left outstanding that he
No,
believed.
according to him.
So he believed that there was a zero.
Right.
Well, and because he thought the quality of the work was poor, nothing worthwhile had been done in the case.
Well, he
For the
doesn't
whole
get a
period of time it was
discount.
being litigated, he thought that nothing more was owed. The arbitrator
He
disagreed.
Did he believe there was that he just wanted a discount from the fees he had paid, or was he saying, yeah, okay, these are the hours that were worked on? I'm just confused about he wanted a zero, as in, he was hoping the arbitrator would say, it's done.
That no more fees were owed. He'd already paid about $140. That's water under the dam. But Mr. McGill was asking for $40,000 or so plus, and Mr. Ball said, no, you don't deserve it. You didn't do anything worthwhile, and I don't want to pay it.
Thank you.
It's important, really, to put into these contracts when you're drafted as a commercial lawyer, when you're putting these contracts together. It's very important to put in there whether it's going to be binding or non-binding, because if it's binding, then the other side has waived their constitutional right to a trial. A very important right. You need to put things in there to say or indicate that there has been a waiver of the right to a jury trial, and nothing was put in there. I've gone through my main points, and I'm happy to
Could
answer.
you address whether someone who represents themselves is entitled to attorney's fees?
You're not. You're not. Even if it's an eponymous law firm, which I had to look up to make sure I was getting it right. Name for yourself, not eponymous law firm. No, the law firm can't charge if it's representing itself, and its only lawyer can't charge if it's representing the law firm. It's just...
If it's a big law firm and there's an associate who's doing the work, there are some cases around the country in federal circuit courts that say that's okay, and they should be awarded the fees.
I don't think that matches Arizona law, and it certainly wouldn't fit this situation where it's a one-person firm. It's really just Mr. McGill with a slightly different name.
What's the rationale for allowing it, in your view? I'm assuming your view is that it's not even allowed for a big law firm with an associate.
Well, are you really paying the lawyer to represent you? If you're representing your own law firm in a one-person firm, you're not paying yourself to represent yourself.
But you're certainly foregoing, you have an opportunity cost, you're foregoing the opportunity, the chance to be doing some work on another client. Is that?
Then hire somebody else to represent you. And that person gets paid, and you get reimbursed, and everything's fine. But that's not the situation. If you're representing yourself, you just don't get paid. That's the way it is.
But do you disagree with if it's a very large law firm and they have an associate who's representing the firm, would they be entitled to? You just disagree with the cases that say law firm?
I would. You're just going around the corner, and no, I don't think there's any difference. I don't think size matters on that particular problem. If there's nothing else,
All right. Thank you, Mr. Abney.
I'll reserve my remaining time.
You may do so. Counsel?
Thank you, Your Honor.
May it please the Court. Greg McGill on behalf of my law firm. I'm representing my law firm, Gregory G. McGill, PC. And that's important based on the last issue that Your Honors discussed, which is when I have to represent in a case like this my law firm, which has overhead and expenses and staff, and I have staff that has to be devoted to these matters, there is a very real and tangible opportunity cost associated with that.
But what about someone else, just a solo practitioner with no, your position is the same whether you're just a solo practitioner with no, you're working out of your garage, not a lot of overhead.
Yes, sir.
You're still would you be entitled to fees?
Well, I viewed this as, the facts in terms of what the reality was in the case, Your Honor, with all due respect to the question. I was representing, and I think Judge Gates understood this, because she had made a comment when she awarded fees. It was $11,000 under the Cannon case.
Well, how does that square with the Munger-Chadwick case? I thought in Munger-Chadwick, the court specifically said that you can't represent yourself and then be entitled to attorney's fees.
Well, I was not representing myself. That was the
Okay.
other thing. Judge Gates noted when she awarded the fees that I was representing my professional corporation.
Okay, but in Munger-Chadwick, that was a firm, correct? And they said Munger-Chadwick's representatives who were members of the firm couldn't submit for fees, right?
Well, right. In that case, it said that, but,
So you just disagree with that case?
well,
And you don't want us to follow that case?
I don't think it applies here for two reasons. One
Because
is,
we're Division I and they're Division II, is that the two reasons?
well, it wasn't a different division, but, Your Honor, I have another basis for fees. I think this appeal, because many of the arguments brought in this appeal go against tremendous weight of authority. For example, none of the statutory grounds were raised in this appeal. None of the statutory grounds under ARS 12-1512 or 12- the revised statute 12-3023. None of those grounds were brought. There were the substantial amount of the case law that's on point, all of it, from McGill to Vertex Steel to Smitty's versus Pasqualetti, which is a leading case that this court
And we
applies.
can talk more about that when we get to the
Sure.
substance of that area. But when it comes to fees,
Yes.
did you, and I'm assuming based on what you said, you're asking that the appeal is frivolous,
Yes.
right? Did you
Essentially,
make a frivolity argument in the trial court? Did you tell Judge Gates, I'm
Yes.
entitled to fees because their defense is frivolous?
I did.
And did she make any findings on frivolity or frivolous?
I don't know that she made any findings, Your Honor, but I did raise a motion under Rule 11 because I had a conferral with counsel where I mentioned to him during the conferral, which is required under Rule 11, and I moved for fees under Rule 11 because I had a serious concern that Mr. Ball was extending these proceedings and delaying the proceedings, which runs counter to the whole public policy basis of arbitration, which is that when you have a binding arbitration award, which is what Judge Skelly issued, and it's not to be ascended up through judicial review unless you have a statutory ground for that, which did not appear in any of the pleadings. So that I argued was part of the Rule 11. The second part of the motion for sanction as a basis for the fees was that the claims that were brought, for example, the claim on employee, for example, lawyers are independent contractors under the IRS regulations and the law. And there is a definition under a statute, it's ARS 23-613.01A, which defines an employee, and it expressly exempts lawyers and law firms from that, and lawyers and law firms are considered independent contractors. So to answer your question, there's a separate basis for attorney's fees that I believe that Mr. Ball has strung this out. I'm almost 2 years past the original hearing. It was just a few months into COVID in 2020 that this arbitration, and I'm still struggling to get paid on this, even though Judge Skelly went my way after a full-blown evidentiary hearing with cross-examination, witnesses, 8.5 hours. He billed $8,000 for the hearing and to review 8 banker boxes that I left. Both law firms knew this was a full-blown evidentiary hearing. The notion that there was a mistake in the pre-hearing statement, Your Honor, with all due respect to counsel, is not credulous because of the full-blown nature of the evidentiary hearing. The pre-hearing statement, they didn't send a copy of that to me before the hearing. I knew it was binding, and we went through
But
a full...
you agree you can have a non-binding arbitration, though? It is something that happens?
I think it happens. I think it's quite rare, though. I think in the industry, in the legal industry...
And are you saying you have to specify that it's non-binding, and if it's not specified, then it's necessarily binding?
Right. If it says, well, to answer your question, the answer is yes, because the case law that I saw, the McGill case, the Vertex Steel, the Smitty's versus Pascoletti, they all point out that when you go to arbitration, as long as you have a full opportunity to go to the hearing, which Ball participated in without objection at the hearing, even though it was a full-blown evidentiary hearing, the cases say that if there's to be a limitation on the arbitration, it has to be express and in the agreement. And there was no express limitation in my fee agreement. That's number one. Number two, the language is very important because it says, if there's a dispute over attorney's fees, a dispute over fees, which is a practical matter, you want a resolution over that. It says you can go to private or AAA arbitration. Counsel, with all due respect, just admitted to you that AAA arbitration, I think virtually every time is binding. And so under the justum generis doctrine, that Latin phrase that we've seen in the law books, when you construe a phrase, you construe it in harmony. You don't parse out one word and parse out another word and construe it so it's not in harmony. So it says we'll go to private or AAA arbitration. AAA arbitration is binding. It's typically binding.
But is the counter-argument then that you chose not to do AAA, you went to a different...
The private arbitration.
Private arbitration that may not be binding?
Well, but the justum generis doctrine is that the private arbitration or AAA arbitration, the reasonable construction would be that they go together and you harmonize the two. Now, there is no doubt at this hearing, and I was there, Judge Skelly knew it was a binding arbitration because he issued an award 3 days later after he billed $8,000 for the hearing and his review of eight banker boxes. He held a full-blown evidentiary hearing with cross-examination. There were opening and closing statements. Mr. Abney was there. Tom Smith was there. Two different law firms. Not once did they raise the specter that it was not binding. They didn't raise it for 8.5 hours with two law firms. And when that decision...
Are you saying it would have been a different hearing if it had been non-binding?
I think if it was non-binding, it would have had a completely different complexion.
How would it have been different?
It would have been different because Judge Skelly would have said, okay, this is a non-binding. This didn't happen, and it should have. That's my first argument. But to answer your question, it would have been different. Well, I've just been asked to give an advisory recommendation. So you've briefed it. I want to hear the argument from counsel, and I might take some statements, but I'm not going to conduct a full-blown evidentiary hearing because this is not an adjudicative matter that would be binding. So I don't need all that. Give me your best evidence and make your pitch. It's an advisory opinion. This was the opposite of that. But the other thing that's telling about that I think is dispositive, it's counsel didn't raise this pre-hearing statement. I happened, during the sanction conferral that I was required to have, I had to have a phone call with Mr. Abney. I had a phone call with him and I had the conferral. This is after he filed his motion to dismiss on confirmation. That's the first time he raised this non-binding, and that's way too late because now he's in court. If you're going to raise a contract issue that's non-binding, you have to raise it at the arbitration. All the leading cases say that. It has to be raised at the arbitration or it's waived.
But his point is the contract doesn't specify that it's binding, and you were the one that presumably drafted the contract, and so his point seems to be that I've just agreed to arbitration. I haven't agreed to binding arbitration, so there's nothing to clarify.
Well, number one, in my fee agreement, there has to be a limitation on that. It says arbitration, it says private or AAA arbitration. AAA, he just conceded, is binding. There's no reason in the world, if he inferred private arbitration to be non-binding, knowing that AAA is binding, which he just told you, then it was incumbent upon him to raise that issue to the arbitrator. All the cases say that. That's a contract issue. That has to be raised to arbitration or it's waived. If you cannot bring that up, arbitration, because of the public policy in Arizona, does not allow arbitration to be the lowest rung in an ascendancy ladder into the judicial review process, because that cuts against the public policy. So he had to raise that at the hearing, but more importantly, 3 days after the hearing, and neither attorney raised that at the hearing, 8.5 hours. 3 days later, Judge Skelly issued the award. An award is synonymous to a judgment. You still have to go to judgment. To get judgment, you have to confirm it. But he issued that as an award, which in the industry has a meaning. Both attorneys got that award on July 24th, 3 days later, and they still did not move to reconsider or move for a stay and address that issue then when they had an opportunity. And all the leading cases say that was their last time that they had an opportunity to raise it, and they waived it. But the last thing I want to mention, this is very important on this, in the pre-hearing statement, not only did they tell Skelly that it was binding and didn't send me a copy, so Skelly thought it was binding for 8.5 hours.
And just to stop you for a second, those are they the confidential memos, or was this just an oversight in not sending you?
Your Honor, I'm not sure if it was confidential, but they submitted a pre-hearing statement to Mr. Skelly, and when you look at it, and it's in the record, that they copied Skelly, but not me. I got it after they filed the motion to dismiss at the court level, which was too late to bring it up. But when they filed when they filed the motion to dismiss, that's when I had the conferral, because I thought this was all delay, just burning up court time on an arbitration that was binding, because it was waived. It was never brought up. And that's what the statute, subsection 5, it codifies implied consent, meaning if you participate without objection, and that's where Judge Gates went. She cited McGill and Vertex Steel, and those holdings have not been reversed, that if you participate, it's implied. She cited that, but the statute, 1215 subsection 5, and the newer scheme, which is 1230-23 subsection 5, which is written more clearly. It hits it on the head and says, if you participate and you have a fair opportunity at the hearing and you don't raise an objection, that's implied consent built into the code. And the judge recognized that by citing the cases. She didn't cite subsection 5, but that's the codification. But the important point on the pre-hearing statement that I would like your honors to appreciate, he said it was a mistake. 2 lawyers made a mistake at the hearing and didn't try to correct that when they got the award 3 days later. That's very telling. But here's the most telling thing. The prayer for relief in that same pre-hearing statement, if you look at the prayer for relief, because that's very revealing, it says that they were requesting a substantial reduction in fees from this arbitrator. That's the relief that they pled. So the pre-hearing statement is not only revealing in that it said it's non-binding with 2 law firms and not corrected when the award came out 3 days later, but their prayer for relief revealed that had they won, they were asking for, quote, a substantial reduction in fees. That's not asking for an advisory opinion or a recommendation. That language is dispositive on that. And it's a little bit troubling to me, perhaps it is to the panel, this mistake argument after that. And that pre-hearing statement, even in the reply, after I had a conferral, it was the motion to dismiss, the telephone conferral on the Rule 11 sanction, and then I filed a response, and then counsel filed a reply. Even after the conferral, when I brought this to the attention of Mr. Ball and his attorneys, after the conferral, before the reply, they still did not disclose to the court the pre-hearing statement and hit it head on and try to explain it as a mistake. They didn't tell Judge Gates, and they should have. I brought it up. I then filed, after the reply on the motion to dismiss, I informed the court because I felt compelled to tell Judge Gates and to be candid with the court and let her know, oh, by the way, they're saying it's non-binding. but they issued to the arbitrator an arbitration brief that said that it's binding, and they had a prayer for relief asking for a substantial reduction in the fee from this arbitrator, quoting it verbatim.
Counsel, I just want to jump really quick
Yes.
to the fees issue again. Are you the only attorney in your firm?
No, my son is an attorney, Ryan McGill. He graduated from the Sandra Day O'Connor School of Law, ASU. He's an attorney in my firm. He was a clerk at the time, but I had.
And what's your best authority for getting an award in light of Munger? What's the best authority? Munger seems to say you represent yourself, you don't get fees.
Well, counsel, I think that, number one, I think there's a fee basis because I think that this appeal goes against all the weight of authority on the law and the
But you're
facts.
saying we could make a ruling on our own if the court hasn't awarded, the court below did not make an award on that basis, we could just look at it and say this is a frivolous appeal and we're awarding fees below based on what we think was a frivolous appeal?
My understanding, Your Honor, under RCAP 21, if there's a legal basis for attorney's fees, then you can award fees. Now, you could award it on the basis that it's a frivolous appeal, or even if you don't get to that threshold, you could award the fees if it's a close call on the attorney fee issue because they've consumed the court's resources and are taking up the resources when the facts and the law don't support it. But to address Mr. Abney's argument, and I think you were correct earlier. I think you were spot on when you suggested there's an opportunity cost. And Your Honor, I know you mentioned the other case, and I understand that, and I appreciate that very much. But as a practical matter, my PC, Gregory G. McGill PC, is a professional corporation. It's separate from me, and it has to be represented by counsel.
Did you have a fee agreement between yourself and the firm for this matter?
Yes, I did.
And
Between myself and the firm.
did the firm pay your attorney's fees in this matter?
No, let me address that, because that's where I was going next. That's a
Okay.
very good question. That's where I was going next, because what counsel is saying to the panel, this is basically what he's saying. Even though the PC has to be represented by counsel, and even though there is, as a practical matter, an opportunity cost, and the court mentioned that other case in that large law firm, there is a very real opportunity cost. And what he's saying is, I would have to hire another law firm to represent my PC, and then against Mr. Ball in this matter, pay that firm, and then try to get the attorney's fees back. And I'm drawing an inference, but I think that Judge Gates looked at that and said, no, the PC has to be represented. It's separate from McGill. The Cannon case allows it. And at this level, the Steer case, and I cited the case as Steer, S-T-E-E-R, I cited that case allows it at the appellate level. It exalts technicalities in form over substance and practicality to say I got to pay some firm, $30,000 and then pay them and then submit an application to the appellate court to get reimbursed the fees, as opposed to billing my fees to represent my corporation.
So it sounds like you're making a policy argument. This
It's a
opportunity cost is a
policy
policy argument, but that
Yes.
doesn't get around the Munger-Chadwick case.
Right, and it's a policy argument, and I think, but it's a practical approach, and it gets out of the arena of theory and more into a practical arena. And again, I think this court has the authority, based on the fact that there's no facts, nothing was brought under the statutes. I think one of counsel's arguments was that the statute doesn't apply, but one party cannot opt out of the statute. The statute says, here are the narrow grounds to contest an arbitration award. And subsection 5 says if you participate with a fair opportunity at the hearing to be heard, and you participate, which Ball did, and I submitted Ball's checks.
Counsel, your time has expired.
Yes, sir. I submitted his checks. He participated. Thank you, Your Honor.
Thank you. Mr. Abney?
Thank you.
If I may just touch on Munger versus Chadwick, it says that a law firm cannot obtain its fees through an arrangement that amounts to self-representation when a sole practitioner would be unable to do so. It adds that a law firm cannot hire its own attorneys as if they were outside counsel. and that the rule forbidding an award of attorney's fees when a party represents itself does apply to law firms. So Munger Chadwick is on point.
Well, and I'm not saying it's not, but we don't have to agree. It's the beauty of being on the Court of Appeals, Mr. Abney. We don't have to agree with each other.
Well, I've run into that recently, Your Honor. Yes.
And my point is, the opportunity, when you look at opportunity costs, why would we draw that distinction? I mean, clearly, if he's spending his time trying to get what he, I mean, I realize you disagree that he was entitled to it, but if he's trying to get that judgment enforced, he's not being able to spend that time doing something else. So there's a real opportunity cost.
Right, but the underlying policy, I think, behind the Munger Chadwick kind of rule, and it goes way back, is that there's an awful lot of incentive there to sort of fudge and inflate when you're representing yourself. And
But
so
don't
the
you have
court
to
say you
have-
can't do that.
Doesn't the court have the obligation to review a request for attorney's fees? The court's not going to simply say, oh, sure, you billed $100,000, we're going to confirm that.
Sure.
Isn't there a protection against that?
There is some, but then again, our protection here is this line of cases saying you can't do what he did.
And wouldn't your argument apply to other fee awards as well? I mean, why is there a difference between a firm representing itself and a firm representing another client? Is there not the same opportunity to inflate costs?
Yes, but the courts have said that this is a particularly troubling situation and this is the rule we're going to follow. And it goes back maybe hundreds of years, but I know it's decades back.
But there are other courts that disagree. I mean, there are other jurisdictions that disagree with this
Sure,
case.
yeah.
Isn't the general rule you can't represent yourself? Here, they have to have an attorney in court to represent them.
I believe so, yes.
It's a little different. Obviously, you're not a lawyer, you're not getting attorney's fees, even though you've got opportunity costs and whatnot.
Right.
But here, you have to have an attorney represent you.
Right.
So it seems like kind of an artificial distinction to just say if you hire someone else, we'll pay them, but if you represent yourself and do it cheaper than someone else, we won't pay you.
Well, stare decisis, although that doesn't work always. But there's a good reason for this, and I think, the courts have made a choice.
But what is the good reason in that situation? If we're clearly going to award fees if you hire outside counsel, and the court's going to review the reasonableness of the fees, as opposed to somebody representing essentially themselves, but having to have the court review the reasonableness of the
The
fees.
good reason is historically there have been problems with self-representation, so the court decided this is the rule, the bright line rule. You can change the bright line rule if you want. Sometimes that can be a very good thing. Sometimes, as with Dram Shop, that can be a very bad thing. But that's a different subject, and we could deal with that later.
Well, Mr. Edmund, I do have could this be imposed as a sanction? Rather than just the awarding of attorney's fees, can it be a sanction?
Attorney's fees can be awarded as a sanction. No sanctions are proper here. I mean, we are raising some interesting...
And to be clear, Judge Gates did not impose this as
No.
a sanction.
In fact, he filed a motion for sanctions, a separate motion, which he declined, which was denied. The settlement, the arbitration statement was confidential. That's why it wasn't circulated until later. We didn't realize, like I said, we didn't even realize what was on it. And I'm sorry about that. I mean, I was reading the opening brief and the reply brief today, getting ready, and I spotted a typo in each of them. It makes me want to hang myself. These things happen. You do these mistakes, and you try hard not to do it. And then once you do it, you're blind to it.
Have you gone, as a general rule, have you submitted to non-binding arbitration? Have you represented clients in non-binding
Yes.
arbitrations on a regular basis? Is that
No,
something?
no. Well, I don't do commercial stuff, and I don't get involved down in the beginning of tort cases. I get involved later on.
When you've done a non-binding arbitration, did you specify before you went into the hearing that it was going to be non-binding?
Everybody knew it was non-binding going in. The last one I remember was John Long. Remember John Long? He had Maryvale and Bale and all that stuff. It was about his wife and a piece of property, and it turned out it was a non-binding arbitration.
Well, did your client think that the other side believed this was a non-binding arbitration?
Did Judson think that? Judson Ball?
And you representing him, that it was going to be a non-binding?
We all did, all three of us did, and we figured he did too, but, it just never came up.
See, I do find it somewhat persuasive that my understanding of non-binding arbitration is it's more of, here's my argument, and arbitrator, you get to kind of decide that, and it's much more informal than the arbitration process that happened here.
It's far more like a mediation.
Right,
But
non-binding.
at the end of it, there's going to be an award. And then you can do with the award what you want. You can say, we've got an award here, we're going to go to court, we've won already on this arbitration, and now we're going to go to court, and we're going to win, we already won once.
Okay, so you show up here, and you're putting witnesses under cross-examination, and you're swearing them in. That sounds like a full-blown binding arbitration, doesn't it?
Yeah, it sounds that way, but it wasn't. I mean,
It
Mr.
walks like a duck, quacks like a duck, but it's not a duck.
And to
It's
Judge
not a
McGill point, if the fee dispute was over about $45,000 in fees, why would your client be willing to pay $8,000 to $9,000 in arbitration costs if it was just an advisory ruling?
Because he had agreed to the arbitration. And he's a man of his word. He said, okay, I agreed to this, we're going to do it, and I have to pay half, I'm going to pay half, and that's just the way it is. I agreed to this, and we're going to do it. What was the duck walking and talking about? It was.
We were talking about the fact that he showed up and participated in what, from all appearances, it was a binding arbitration, and then, oops, it's not, it wasn't.
Right, it was actually full of storm and thunder, signified very little. And the reason, the witnesses were Mr. McGill, I think his wife, and then Judson testified, and I can't remember anybody else.
But they were sworn, they were cross-examined.
Right.
Not that I've seen every single case, but that doesn't sound like a non-binding arbitration procedure to me.
Yeah, it sounded like one to me. It was very informal. From our side, we were very relaxed. We were smiling and enjoying being there. Chris Skelly's a wonderful person. It was not a stressful event for us. And just one more thing about timing. They filed for confirmation of the arbitration award, which was fine. I mean, confirm a non-binding arbitration award, that's fine. We filed a motion to dismiss, they filed a response, we filed a reply, and right after that, the confidential memorandum was turned over, routine discovery, and all of a sudden we get this motion for sanctions, and everything's blown up.
All right, thank you, Mr. Abbey.
Thank you.
The case is deemed submitted. We'll issue a decision in due course. Thank you for your briefing and your argument.
Thank you.